Hello children. As you know, there are three organs of the government. Executive, which implements laws, legislature, which makes laws, and judiciary, which gives justice. In this lesson today, we will learn more about the Indian judicial system. Why is giving justice important? And why is unbiased judiciary required? Opinion, thoughts, perspective, beliefs, faith, and culture differ from person to person. If people are tolerant, they can avoid conflict. But if there is a difference of opinion, then it leads to conflicts. These conflicts should be resolved impartially and in accordance with the law. For this purpose, an unbiased judicial machinery is required. Conflicts of interest arise between individuals and the government. People might think that certain laws passed by the government or certain decisions made by the government are unfair to the people, and they may approach the court for justice. The government tries to implement social justice and equality. The judiciary, through its decisions in cases or through active involvement, supports the government. The court can help to bring the weaker sections of society like women, children, differently abled and transgender into the mainstream of the society. The rule of law is protected by the judiciary, which means the law treats everyone equally, no matter whether the person is rich, poor, forward, backward, whether it is a man or a woman. All are equal before law, and this is expressed clearly through judicial decisions. Judiciary helps to protect the rights of people. Let us look at the structure of the judiciary. Now, India is a union of states, which means there is a separation of power between the center and the states. But the judicial system is different. There is one system for whole of India. It is an integrated system or a combined system. The Supreme Court is the apex court or the topmost court, under which there are high courts, followed by the district courts, and finally the lower courts. Let us look at the Supreme Court. The head of the Supreme Court is the Chief Justice of India, and he is appointed by President of India. The senior-most judge of the Supreme Court is appointed as the Chief Justice. The judiciary should be able to work independently without any kind of pressure. For this, provisions have been made in the Constitution. Let us look at the provisions made for independence of judiciary. The first one is an eligibility criteria is given in the Constitution. A person who is a legal expert or has an experience of having served as a High Court judge or an advocate is considered eligible. And the judges are appointed by the President. They have something called security of tenure, which means they cannot be removed from their post for trivial issues or for political motives. The retirement age of judges of the Supreme Court is 65 years and of the High Court is 62 years. The salaries of judges are given from the Consolidated Fund of India, and no discussion takes place in Parliament regarding to this. Personal criticism cannot be made on judges for the acts and decisions. Contempt of court is considered as a punishable offense. This not only protects the judges from wrong criticism, but also preserves the independence of the judiciary. Parliament cannot discuss the decisions of the judges. However, Parliament has the right to remove the judges from the position through the impeachment procedure. Functions of Supreme Court. It has the responsibility to settle the disputes between the center and states or between two or three states. Which means if there is a dispute between the center and state, this dispute goes to the Supreme Court. Or if there is a dispute between two states, like maybe Maharashtra and Andhra Pradesh. So if they have a dispute, then the dispute goes to the Supreme Court. It may also give orders to relevant authorities for protection of fundamental rights of citizens. To review decrees and orders of lower courts and also review its own decisions. For example, if a lower court has given an order, it can be reversed by the Supreme Court. In case the President asks for the advice of the court to understand the legal aspects in matters of public importance and provide the necessary advice. So the Supreme Court can also give advice to the President when they are called upon to do so. Now we are going to look at three terms here: judicial activism, judicial review, and PIL. What is judicial activism? Now the courts settle the disputes whenever they are approached for that purpose. However, we see that in the last few decades, this has undergone a change and the courts have become increasingly active. This means that the court now seeks to fulfill the constitutional goals of justice and equality. The court has tried to provide legal protection to the marginalized sections like women, tribal, workers, farmers, and children. Judicial review. What is judicial review? Now, one important responsibility of the Supreme Court is to protect the Constitution. The Constitution is the fundamental law of the nation. The Parliament cannot make any laws that violates the Constitution. Every act or policy must be consistent with the Constitution. If any law passed by the legislature or any act of the executive goes against the provisions of the Constitution, the said law or act can be declared illegal by the court. Now, this power of the court is known as judicial review. Next is PIL, which is public interest litigation. It refers to litigations filed on issues of public importance by individual citizens, social organizations, or non-governmental organizations on behalf of the people. The court thinks over the questions raised and gives its decision. Next, we are going to look at High Court. The head is the Chief Justice, who is appointed by the President of India. There is a High Court in each constituent state. As of now, there are 24 High Courts in India. The Bombay High Court's jurisdiction covers the states of Maharashtra and Goa and the Union Territories of Dadra and Nagar Haveli and Daman and Diu. What are the functions of High Court? To supervise, maintain control over the lower courts in its jurisdiction. Which means if you see in the case of Bombay High Court, it covers all the lower courts in Maharashtra, Goa, and the Union Territories of Dadra and Nagar Haveli and Daman and Diu. It also has the authority, like the Supreme Court, to give orders to protect fundamental rights. In the case of Supreme Court, the President can approach the Supreme Court for advice. The same way, the Governor can go to the High Court and seek advice while appointing judges in the district courts. District and lower courts. Courts at district and tehsil or taluka level. Every district court has one district judge. Branches of law. There are two branches of law. Civil law and criminal law. First, we will look at civil law. Now, this deals with conflicts which affect the rights of a person. Like, for example, conflicts regarding land and property, rent agreement, divorce, etc. After filing a petition in the relevant court, the said court gives a decision. The next type or the next branch of law is criminal law. Crimes like theft, robbery, dowry, murder, etc. All these cases come under criminal law. In these cases, the first step is to file a FIR, First Information Report, with the police. The police investigates the matter and then a petition is filed in the court. If the charges are proved, there are provisions for severe punishment. The Indian judiciary has made important contribution in development of the country. Common people have a lot of respect and trust in the judicial system because it has protected individual freedom, the federal system as well as the constitution of the country. Courts have played an important role in strengthening the democracy in India. Children, with this we complete the explanation for this lesson. Thank you for listening. Goodbye and take care.